and conditions. Thank you.
Okay, thanks very much. My name's Vincent from Weightmans. I was meant to be joined by a colleague today, but she's having some technical difficulties, so I'm going to have to cover her slides as well, but that's okay. So we've been asked to talk about future-proofing terms and conditions. And really what that means is obviously accommodating change. And those changes manifest themselves in different ways. And we've recently, of course, seen widespread changes required due to the pandemic to a wide range of contracts. So we're going to have to keep this relatively broad brush because we've seen them for construction contracts, FM contracts, as well as standard contracts for the supply of goods and services. But it's really put a focus on the future-proofing terms and conditions. So what am I going to talk about today? I'm going to briefly mention the idea of material change for those of you who are subject to the public contract regulations, and then some examples of change through contracts and what they might mean, pausing mainly around force majeure, change in law, variations and change control. So in terms of material change, then that is dealt with by Regulation 72 of the public contract regulations. So what that mentions is that there are the ability to amend a contract in any way, provided that the change is brought about as a result of what's called a clear, precise and unequivocal review clause. Now, over the past 6 months to a year, we've been giving advice on what a clear and precise and unequivocal review clause is, and we've been involved in some litigation about it. Now, I have only got a few glimpses of what this means, but I'll tell you it's not. It is not a change control clause that just says, if we want to change this contract, we will get together and we will debate the change, we'll agree the change, and then we will give effect to the change by changing the contract, because that's just change control. And you could do that in any advertised contract you like without satisfaction of this requirement. What it is more likely to mean is a clause that says, in the event that X happens, the following changes are made to clauses A, B, C, D, E, or F, etc., etc., etc. And the drafting is precise. So they have to be really nailed on, these clear, precise, and unequivocal review clauses. Where the change is made to stay with the contractor without a retender. I'd stress the word cannot there, so the changes were not included in initial procurement where a change of contractor cannot be made for economical or technical reasons. Not that it's a bit inconvenient, it's that it cannot be made, it's not possible, not even reasonably. It's impossible to do it, or where it could cause significant inconvenience or substantial duplication of costs is another way in which you can modify contracts up to 50% of the value of the original contract. Now, another one, much loved during the pandemic, brought about by circumstances which a diligent contracting authority could not have foreseen. I've been involved personally in litigation where the contracting authority has sought to use this in reliance upon PPNs from this first part of or mid part of 2021 to mean that they've made all sorts of changes under the guise and the cloak of COVID. What you need to know is that these need to be limited in duration to the period in which the state of emergency is preventing you from abiding by the 30-day timescales to run an open procedure. So it's that limited, and it is related to stuff that is necessarily impacted by the pandemic. So it is definitely not a panacea, despite what various attempts at the PPNs have tried to interpret it as. And let's not forget, it's the courts who are the arbiters of this, not Crown Commercial Services. So there's another change where there is a takeover And the takeover is defined quite widely: merger, acquisition, or a change in to the position of the initial contractor, provided that it doesn't involve substantial modifications, and of course that the initial terms for precondition are met, which means that the replacement contractor must have passed the initial SQ questions that you were asking. So this last slide of material change codifies case law. Cases going back to 2009 called Pressitext. So it'll always be, unless it's a clear and unequivocal review clause, be material change where the modification renders the contract materially different in character. Modification introduces conditions which would have allowed other people to participate, or the acceptance of the tenders, or a very nebulous one which has attracted additional participants, which is always a very difficult one to nail down. Would the change have attracted somebody else? Well, that's a very subjective thing, and we always get involved in. That's a very litigious area that I've been involved in quite a few times. It extends the scope considerably, changes the economic balance. Oh, it's frozen for a second, so let's go back. So in terms of term and expiry, what changes can be accommodated there? So obviously we talk about different things here: fixed term, a rolling contract, and a hybrid. Quite often suppliers will like a rolling. It makes it quite hard for you to terminate on them. You've got to be mindful on that basis that of the points I've made about material change, and also for yourselves, fixed is seldom a good idea. So what you quite often end up with is renewable for multiple fixed terms, or to serve out essentially an initial term where you can't terminate, and then have different rules of termination for different time periods thereafter. Largely that will be down to how much capital outlay the contractors have to put into the deal, because they'll want to secure a certain amount of return before you have the ability to terminate for convenience. Force majeure, here's a good one. Depends on the drafting of your force majeure clause. And what you've got to look at, whereas once upon a time these were just boilerplate clauses that everybody just banged into a contract without much thought, surprisingly enough, for the last 2 years they've become a lot more considered, a lot more detailed, and particularly you're looking for specific examples of where the fit the circumstances. So epidemic and pandemic. I had one that was that said pandemic. That said epidemic, but before the UK government had declared an epidemic. Pandemic, it turns out, is something that applies to the whole world. We could easily prove that. What we couldn't get a handle on is what the epidemic was, and that took quite a bit of litigation and to and froing. You'll also got to watch out with a force majeure clause that it's not interpreted as an exclusion of liability clause. So basically it says, if something happens, then we're excused performance of the contract, full stop, completely. Because that is then an exclusion clause rather than a force majeure clause. And that's subject to rules on reasonableness and unfair contract terms and things like that. So just be mindful of that one. So for force majeure, look at what it says around, is it prevented, hindered, or delayed? Did it just say prevented? How foreseeable is it? I've had cases where which is you're trying to rely on force majeure clauses where it's entirely foreseeable that there was going to be second waves of the pandemic, third wave of the pandemic, etc. In fact, everyone was predicting it. So immediately reliance on the force majeure clause became terribly difficult because it failed at the foreseeability part. What are the notification requirements? There's always an obligation to mitigate, as in to soften the blow with what's happening, and to not run up liabilities on whoever's picking up the debt. So what's the consequences? There's a no breach, an extension of time, an extension of money sometimes, or a right to terminate. what's the relevant date for the event of the clauses in question? So another key one is a change in law clause. Usually they say things like it's things to do with changing regulation, law that impose some sort of change on the contractor. I've seen them widely drafted for things like Brexit, but they tend to be quite specific sometimes as well. So things to think about in relation to those is, when does this start? So when's the base date from which you're working to enable to work out sort of what the relevant date was? Is it submission of bids or contracts signed? It's probably going to be submission of bids unless you define it as a commencement date in the advertised contract, because the submission of bids is a date at which people were looking at the contract in order to build up their best bid portfolio of prices and risk assessment. Which law is it? Is it just law, regulation, and of whom? Is it a particular, because now we've got devolved government in the UK, just be careful if it says England or Wales. Northern Ireland is a particular issue, obviously. And what about is it laws in force at a relevant date or from time to time? So that means as laws change, then the effects are rolled into the new contract. And what happens to give rise to a termination? How bad does it have to get in order to be able to terminate? Changing to payment terms in the event of flexing a contract, as we were encouraged to do in the PPNs. So you'll want a longer payment period in case cash flow is interrupted, so that you're able to make the payments when cash permits. They'll obviously want shorter payment terms to avoid supplier insolvency, and that is encouraged, of course, by the PPNs making advance payments. And what happens on termination for delayed payments or outstanding charges? Reach a limit. So if you're not paid a certain amount, does a contractor then say that gives them a termination right and a right to sue to recover? So a change control clause, there will be, in standard terms, that's just a meeting of minds where you get together, describe the variation that someone wants, someone then submits a proposal, and then you agree it by a variation agreement. And that usually works, unless, of course, it relies on agreement, and then you're then stuck with the contract unless they agree it, which then puts the bargaining position into their sort of control. Another way of doing it on complicated agreements is a formal one with procedures and timescales and an escalation procedure, so that people can know where to go to in the event. I've seen change control clauses ending up in a mediation process, and of course there are limits to where you can go to if you believe you are covered by the PCR, and I've covered that under Regulation 72.
Martin, sorry, can you hear me?
I can hear you.
Oh, hi. Apologies, I have managed to join via phone if you would like me to take over from here.
You have prepped it. I am merely winging it, Gemma, so you feel free.
So apologies about that, everybody. I've been having some technical difficulties with the microphone on my laptop, but I have managed to join via phone, so apologies for any delays. So I'll just pick up from where Martin just left off. So another key consideration when we're future-proofing contracts is the events under which we might want to terminate the contract. So that might be on the basis of a fault-based termination. So I have set out on the slide here some examples of fault-based termination events that we commonly see within contracts. I won't take you through each of these in detail, as I'm sure that you are quite familiar with them, but I'll just touch on a few in a little bit more detail. So material breach of contract it's quite common to define what a material breach can be. However, we would just flag to you that in doing so, you need to ensure that that definition isn't exhaustive on the basis that we don't want it to be too restrictive. It's quite difficult at the onset of a contract to actually think up every circumstances that might actually be a material breach under which you'd want to terminate. So it is good to leave that relatively open. You might also want to consider having a period within which you allow, say, a supplier to remedy any breach, so say 30 days from the date when the breach first takes place. I also just want to flag in relation to insolvency related events that there is the new Corporate Insolvency and Governance Act, which came into effect in 2020, which has made some amends to the Insolvency Act. It actually restricts the ability of a supplier to terminate when an insolvency related event occurs. So even if you set out within the expressly within the contract terms that the supplier can terminate if an insolvency event of the customer arises, actually you just need to be mindful of those restrictions under the Insolvency Act as well now. Just within this list, I'll touch on procurement challenges. So under Regulation 73 of the PCR, there are some termination trigger events that are implied into contracts. So if a contract is subject to a substantial modification requiring a new procurement procedure, or if one of the mandatory exclusions applied and the supplier should have been excluded from the procedure. In addition to that, you might also want to include a right to terminate generally if you receive a procurement challenge. Now, you might receive pushback from suppliers on that basis. So sometimes sort of a meet in the middle and a negotiation is to make that subject to the procurement challenge having reasonable merits. So in addition to fault-based termination events, you might also want to consider rights to terminate for convenience. So that could be, a mutual right for both of the parties to terminate on, say, 6 months' notice. We don't know what's going to happen in the future. It might be the case that you're perfectly happy with the provision of services, but actually, there's some changes internally, operationally, and you don't require the services anymore, in which case you might just require a right to terminate for your convenience. Martin, have we lost the slides? Do you have?
Oh, sorry Gemma, I thought you'd taken over as host.
Oh, no problem. Sorry. Oh, bear with me. Are you able to continue to share them, Martin, please? I seem to not be able to via my phone, because I'm on my phone.
Right. Can you see that?
Yeah, apologies.
Which one are we up to?
I think it was coming on to exit planning.
There we go.
So in addition to termination, it's good when we're future-proofing contracts to think about what happens when we actually exit from the contract. So that might be on expiry of the contract, or we might have exercised one of those rights to terminate earlier that I've just discussed. It's important to consider exit planning right at the start of a supplier relationship as far as you possibly can. It can prove very difficult to negotiate exit management terms once a relationship has begun to break down. Provisions should be included to ensure that there is as minimum disruption as possible if we do decide to terminate. So fundamentally, provisions should address access to things which will be required for the customer or a successor contractor to continue to deliver any services going forward. So some key things that I've picked out are personnel. So that includes the operation of TUPE, assets. So that might be, say, machinery or equipment that are used to deliver the services, intellectual property rights, data, and any contracts or subcontracts. So reprocurement and the transition of services to a new supplier should also be considered on entry. It's essential that you have a contractual right to request from the supplier the information that you require regarding the current services. So that'll enable you to, formulate a specification and, if needed, run an adequate re-procurement. So I'll take you through each of those key considerations that I've picked out in relation to exit planning. Martin, are you able to change the slide, please? Okay, so starting with supplier personnel and TUPE. So TUPE, I'm sure you're all aware of the transfer of undertaking regs, apply to relevant transfers. So this includes engaging a contractor to do work on your behalf, reassigning a contract to another contractor, or bringing work in-house. Where there is a relevant transfer, the automatic transfer principle applies. So this means that the transferee will inherit all of the transferor's employees assigned to the relevant undertaking. So that's just the relevant services that we're considering. And most of the existing historic rights, liabilities and obligations will also transfer over. So TUPE does restrict employers from undertaking certain acts around the time of exit. That includes changing the terms of employment and dismissing staff, subject to some exceptions. Contracts will usually have TUPE in and TUPE out provisions, but that will depend on the circumstances at the time and whether services were previously provided in-house, etc. Okay, thanks, Martin. So when we're drafting exit provisions and we're trying to future-proof in relation to exits, when we're looking at supplier personnel, there's some key things to consider when we're actually drafting the provisions. So the first of those is employee liability information. So under TUPE, a supplier does have to provide that information to you at least 28 days before the transfer date. So under the contract, you need to try to ensure that the supplier has to provide anonymised details of employees engaged on the services, terms of employment, disciplinary records, grievances and claims, and so on. Importantly, you should ensure that the supplier is required to provide this information well in advance of termination, as such information may be required to conduct a re-tender exercise or re-let the contract. So TUPE does say, you have to provide this information at least 28 days before. That doesn't mean that we can't have a contractual provision as well that actually says you need to provide this information further in advance. The sooner we get this information, the more helpful for us. And 28 days isn't really going to be sufficient if we need to undertake a further tender exercise to re-let the contract. If you do find yourself in a situation where there are no contractual provisions regarding early provision of information, so only that 28 days applies and it's not really sufficient timing for a procurement procedure, you might want to tell bidders what to assume for the re-procurement. So this would ensure that you're comparing like-for-like bids. So you may say, for the purpose of your submissions, you should assume that 10 members of staff undertaking X roles will transfer. However, the difficulty then arises in the event that that actually isn't the case, and then you have to try to undertake some sort of reconciliation exercise between the bids on the basis that actually, there's more or less members of staff transferring. So it can be quite difficult to do that. An alternative option is to treat TUPE costs as a pass-through cost. So you tell bidders to assume that there'll be no TUPE costs at all, and then you just indemnify the successful bidder, subject to some conditions such as mitigation in relation to any costs that they've incurred in relation to any TUPE transfers. So another point to consider when we're drafting personnel exit provisions is no moving of staff. So you might want to restrict the current supplier from moving staff onto providing the services or off service provision. It's almost to prevent the supplier from cherry picking which staff it wants to keep and which ones it wants to get rid of. Having this provision, it also ensures that any employee liability information that you have received, that might be quite in advance if you do have those contractual provisions, does remain accurate up until termination of the agreement. Finally, in relation to personnel, we need to consider indemnities. So they need to be suitably drafted into the contract. So we want to consider things such as the accuracy of that employee liability information that I've just mentioned, any employee claims relating to events prior to the transfer date, and any failure by the supplier to comply with any requirements of TUPE. Thanks, Martin. So another key consideration when thinking ahead to exit is assets. So you need to ensure that you have access to assets required to continue providing the services without interruption. So the seamless and timely transfer of any assets at the end of the agreement may be vital to minimise impact to services. So you need to seek an option to purchase, but you need to be careful. You need to carefully look at the drafting to ensure that you're not obliged to purchase. So it may be the case, say, that you need a certain piece of machinery to continue providing the services, but it actually, becomes apparent that this piece of machinery is actually really run down, and it would be more financially beneficial to go elsewhere and just buy a new piece of this machinery to provide the services going forward. In that instance, you wouldn't want to be obligated to purchase the rundown piece of machinery from the supplier. So just be careful there when having a look at the drafting that it is an option to purchase. Additionally, you might also want to add a provision that requires a supplier to maintain an asset register or a database of assets, which sets out all the assets that are required to deliver the services. It might also set out within that asset register, which is really helpful, which assets are used exclusively and non-exclusively for the services. It would prove quite difficult to get a supplier to agree to transfer assets to you that they use non-exclusively for the services, so they actually use it for service provision for other suppliers. On that basis, it's helpful throughout the duration of the contract for you to be able to monitor what actually is used exclusively and what might transfer over to you on exit, so you can make alternative arrangements. It might be that you need to procure some replacement assets from elsewhere. You may agree that certain assets will be transferred to you free of charge on exit. Alternatively, you might wish to include options to purchase certain assets. So you might want to include within the agreement a valuation mechanism. As much as possible that we can agree on entry into the contract, the less potential there is for any disputes down the line and issues on exit. So other terms to just consider in relation to assets. You need to ensure that there's adequate provisions in relation to the transfer of title, that there's appropriate warranties if they're agreed commercially in relation to the quality of the assets, and potentially you might also want to request that the supplier novates over any warranties that they have the benefit of. Some assets might also be leased to the supplier, or they might be subject to finance agreements. Again, you might want to include provisions that provide for the novation of these agreements over to you on exit, so you can continue to use the assets. Martin, are you okay to change the slide, please? So another key consideration when we're looking ahead to the future is intellectual property rights. The default position is that IPR is owned by the party which created it. So background IPR, so that's any IPR owned by a party prior to entering into the contract or developed outside the scope of the contract, usually remains in the ownership of the party that created it. So you need to ensure that any newly created, so commonly known as foreground IPR, that's created by the supplier in delivering any services to you, is either owned by, assigned to, or else is adequately licensed to you on exit. So that's particularly important if any foreground IPR is very specific to the services that have been provided or a specific project, or that you require it to deliver the services going forward. The difference between an assignment and a license is that in the case of assignment, the supplier cannot use the IPR with other customers without your consent, whereas with a license, if it's non-exclusive, it can do so. Usually standard provisions limit use of third-party IPR, but if for any reason the supplier really does need to use that third-party IPR, we need to ensure that we have adequate licenses directly with the third party, or we can have them transferred to us from the supplier. You just need to also be careful that any licenses, if for the use of foreground IPR, we need to use some of the supplier's background IPR, just that any licenses we get from the supplier also cover that background IPR for future use. Okay, thanks, Martin. Finally, just in relation to data and subcontracts, just a couple more things to think about when we're looking ahead to exit. We need to ensure that there's provisions for data to be transferred over to us. So if the supplier holds any of our data during the term of the contract, that it comes back to us or is destroyed on our request on exit. Sometimes it does have to be retained by law, so any provision does need to be subject to that fact. There might also be other data that's not necessarily yours that you need to deliver the services going forward, so you should have provisions to either purchase that data or for it to be transferred over to you on exit. And then finally, just similarly to assets, you should have a think about subcontracts. You might want to ask that the supplier keeps a register of key subcontracts. You might want to consider a template novation deed, and you might also want to consider some restrictions on terminating or replacing key subcontracts up to exit. Thank you, and I do apologise for the delays and the technical difficulties, but if you do have any questions, we would be happy to answer them now, or if you want to send us an email after the presentation, we'd be happy to pick any of those up afterwards.
Hi Gemma and Martin, thank you for that. Just to confirm, I've got a few questions that have come in. We're glad to hear there's not too many. But the first one that seems to have a number of votes, this is, has anyone considered clauses to add into current terms and conditions that both consider and protect against COVID issues, now that force majeure is likely now not able to be used on the likes of COVID as it's known? Who would like to take that one? The protection around COVID, isn't it, really, in the future? Martin?
Whatever happens, you're going to find difficulty in drafting a clause that addresses all of the variables if you seek to define it too closely. So that's why we're still seeing clauses that talk about the effects of if you said, you know, epidemic or pandemic, as I alluded to in my stuff, it's about the definition of what fits into that category and who defines it. When you're thinking of these things, you're trying to envisage what are the scenarios and what are the consequences. So I have seen specific COVID clauses, and they deal with essentially delay and ability to terminate. And so for me personally, I see them as a variety of a force majeure clause rather than a thing in their own right, but it is more of a prescriptive, or maybe it's an access to a change control procedure sort of trigger that says in the event that there is a thing that befalls you or somebody else or a part of the supply chain or society more generally, and that needs careful thought of defining what are the areas of the contract that are subject to change and who has the final control over whether those changes are acceptable or not. So it's drafting along those lines is what I'd say about that.
Okay, I suppose adding to that, Martin, thanks for that that response. Another delegate has mentioned a similar topic again, but in future categorising under the World Health Organization, saying that would protect from similar incidents. I suppose they're trying to bring in a wider range of covering at the top.
It's a definition, and generally speaking, I favour careful thought when it comes to definitions, because one and defining by third party what it means. So the WHO is is probably a good idea. So if they call it an epidemic, it is, but if they don't, it isn't. So you provide for an arbiter for these sort of definitions, and of course the important thing is when the date at which they come in. So it's when picking some third party who will be able to define when it fulfills a definition is worthwhile doing at the start.
Okay, that's very helpful. Thanks, Martin. Another one's quite a specific one here. It's on a vending contract that has gone from a single supplier using a full-time role to being split between two suppliers. Would duty apply, and would the incumbent staff member need to work for both companies? It's quite a specific one for you there.
Sorry, Lorraine, I was struggling to hear you then. I think I'm having a bit of feedback.
Okay, well, what I'll do, Gemma, because I think the connection's faltering a little bit now, we'll send that one through, and if we could get a response on a specific requirement there, that would be really helpful.
Yeah, absolutely.
Okay, that's great then. Well, that's all the questions we've got from delegates. And I'd like to say thank you to Martin and Gemma for the time that you've given us today. So sorry about the technology letting us down a bit at the start. Hopefully the session has made amendments for that. We hope you all found the session useful and informative. The next two sessions that we've got are Government Construction Playbook at 1 o'clock and the Real Living Wage, that starts at 1 as well. So please do visit suppliers and their exhibition hall. I'm getting a lot of echo here, so I do apologise. And do log on to the next workshop. Thank you, everybody, and thanks to Martin and Gemma. Goodbye.